Do you own a piece of real estate and are looking to sell it here in Cherokee County and you're thinking about filing for divorce? Well, in today's video, we're going to talk about the 5 things that you need to think about ahead of time before you make the decision to either sell that property or file for that divorce. If you like content like this, educational content about the real estate industry and specifically about buying and selling properties so that you as the consumer are informed, then please go ahead and subscribe below. Give us a like or a comment so that we can respond to you and give you the information that you guys need to make the best decision. Let's get into this. Welcome back. So today's 5 things that you need to know before filing for divorce in Cherokee County. It's specific to real estate and what you want to think about if this is the path you're going to go down. Just because you're filing for divorce doesn't mean it's not an amicable divorce. And it also means even if it's amicable doesn't mean at some point during the negotiations that things might go sideways, because that's human nature. So the number 1 thing you need to think about is when you file for divorce and it becomes active, an automatic stay is placed on the title here in Cherokee County. What does that mean? Well, what that means is when they go to pull title, even if you guys are in full agreement looking to sell the property, what happens is the title attorney looks at it and says, well, there's a divorce case on this and the judge hasn't ruled either way to be able to do something, so this is what's known as a cloud on title. And they can't actually close the transaction without the court's approval or intervention. Number 2, title versus mortgage. It is entirely possible to be on title and not be on the mortgage. It's also possible to end up giving up your interest in the title and still be responsible for the debt on the property. So what does that look like? I'll give an example. Let's say both parties use their income to qualify, so they're both on title, they're both on the mortgage. In the divorce situation, one party gets to keep the house. Let's say it's the wife. The wife is keeping the house and she wants to stay in it. So that's your scenario. The husband was on the mortgage at the time they did it. He quit claims his interest off and moves on with his life. He goes to apply for another mortgage to be able to purchase his own home. However, they're looking and saying, you still have a mortgage. But he goes, well, my wife got that house in the divorce. Doesn't matter, you're still on the mortgage. So another step has to be considered. Do you, in the agreement, negotiate to say she gets to keep the house, however, she has to immediately refinance the house. She has to refinance the house within 6 to 12 months. These things need to be taken in consideration because it will affect your debt to income. Number 3, if both parties said, look, neither of us are keeping the house, we need to sell this. Part of those divorce proceedings, you can actually negotiate and agree upon who's going to be the decision maker during the sale process, and you can even list in there which agent you're going to hire to be able to do the job. There has been many scenarios where divorces have taken place and I was listed as the agreed upon agent because both parties trusted me to be able to do the transaction and keep them both equally informed while navigating this difficult process. So you can agree on that up front, and sometimes it helps because if it's in the agreement, then when emotions run high, it's already in stone, so we don't really shift the direction it's going. Number 4, if you're the party that's keeping the house and being awarded the house, one of the things we see all the time is it says in the decree that, I'm going to use the example again, the wife keeps the house and the husband has to give it to her. But they don't go through the process for whatever reason and do a quitclaim deed actually moving title solely to the wife. Now, if the wife is going to go get a refinance or decides to sell the property, even though the agreement says she has sole power to do so, unless the agreement was written in such a way that it clears up the cloud on title, what we've run into in the past is where the wife wants to sell, the husband is not reachable or is uncooperative, and we as a real estate agent need both sets of signature because they're both showing up on title. Now, what often happens in that case is they will provide us a copy of the divorce decree, and we will send that to Thomas and Brown, and they will review it. If the language is written in there in a certain way, they can use that decree to go ahead and clear title and allow the wife to sell solely with her own signature. But there's been many cases where even though it said she was awarded the house, it wasn't done where it actually transferred the title, and we had to get cooperation or at least a quitclaim deed, something from the husband to be able to get the attorney to be able to close title and insure it. So you get into these hairy moments in here, so it is always helpful to consult with an attorney on the front end to make sure that you get this done right. Now, obviously in a divorce situation, you want to consult with a divorce attorney, but you might also want to talk to a real estate attorney to find out what needs to be done with the title, either in the divorce process, before the divorce process, or once the decree has been issued on the back end, because those are the three possibilities. Number 5, if you're not going to sell the property before the divorce is filed and you're going to do it during the process and cooperate with each other, it is entirely possible to split the costs and the expenses that need to go into the house to achieve the results you want. So for example, let's say a house ends up needing $15,000 worth of repairs and only one party has the money to be able to do that. And at the end of the day, it's agreed that the proceeds will be split. You can, with your attorney's help, be able to document what was put in and who gave that money, and make sure that at the end that the party who gave the $15,000 is reimbursed or it's subtracted from the net proceeds before the split takes place. What I mean by that is if you're splitting it 50-50, you just put in $15,000, you need to recoup that $15,000 expense and then split the other $100,000 worth of proceeds between the two of you. And that can be done. It just needs to be documented properly. So my final words on this is I'm not an attorney and I don't give legal advice. I only give real estate advice and not real estate law advice. We refer real estate attorney business to Thomas & Brown. If you have a need to have a consult to ask about how your property is affected, speak to your divorce attorney, and you can speak to Thomas & Brown as a title attorney that transfers title on property to talk you through some of what the pitfalls are. If you're looking to work with a real estate agent on this process who knows how the divorce process works, that will work in conjunction with your divorce attorney and a closing attorney to make sure that you have clear title and are able to transfer it without a problem, then give us a call and we'll put together a free consultation to talk about the situation and the possibilities so we can find the best win-win situation for you. Divorce is never fun, it's often expensive, and you still can find a win-win outcome for you and your family to be able to move on, deal with the property, and create a win-win situation out of a situation that's unfortunate. Thanks so much for tuning in. Don't forget to subscribe and comment below if you have any feedback. Thanks so much.